Good afternoon, everyone. I'm Elaine Alston. I've been a California litigation attorney for 34 years. As a litigation attorney, I've handled a wide diversity of matters. I've been very active in the landlord-tenant arena for about 30 years. I've handled hundreds of residential eviction cases, including those arising in mobile home communities. I have represented both landlords and tenants, but primarily landlords. I have defended fair housing complaints on behalf of landlords. I have drafted rental agreements, rules and regulations, and other management documentation. I am generally prepared to provide advice regarding many of the questions that arise on a day-to-day basis in the landlord-tenant arena. I am a very proud member of Koppenbarger and Koppenbarger. Our firm has been providing legal services for over 45 years. We have a very strong team of a dozen attorneys with a vast array of knowledge and practical experience. We have a very dedicated staff that helps ensure that we provide stellar services to our clients. We have 8 offices throughout the state of California. We can also meet with clients virtually via Zoom, Microsoft Teams, and of course, the old telephone system. Today's agenda. I have chosen the topics for today's webinar based upon recent experience with clients and the new laws that are taking effect this year. We will briefly discuss anti-discrimination laws, rental agreements, the new security deposit law, policies concerning animals, the new just cause eviction law. If you enter the rental market as a landlord, you are subject to both the federal and state laws governing discrimination. Tenants are the beneficiaries of those laws. These laws include the federal Americans with Disabilities Act, the ADA, California Fair Housing, which is FEHA, and California Unruh Act. These laws control your advertising, rental agreements, rental policies, and even your evictions. You are prohibited from discriminating based upon race, color, religion, gender, that's gender ID or sexual orientation, family status, which is essentially whether somebody's married, whether they're cohabitating, whether it's a family with children. You are also prohibited from discriminating against the national origin of somebody, their ancestry, against people who have disabilities or people who have a specific medical condition. Even the source of income can be an area that you can't discriminate. And that tends to be concerning where if people are receiving government aid. You can't advertise in such a manner that discriminates. For instance, you can't advertise apartments as being perfect for female tenants, or apartments being ideal for retired persons or persons without children. You have to watch in what magazines and newspapers that you use to advertise. If you only advertise in a woman's magazine, that could be seen as discriminatory. If you only advertise in magazines for retired persons, that too could be seen as a discriminatory. You can't refuse to rent to somebody who's in a wheelchair, a single mom, a woman wearing a hijab, a blind person, somebody who's gay. The ADA, the EFHA, and the Unruh Act require that if a person with a disability comes to the landlord and asks for a reasonable accommodation, the landlord is required to make reasonable accommodations. The key there is the term reasonable. When a tenant comes to the landlord for an accommodation because of a disability, the landlord must consider the request. If the tenant's disability is not obvious, then the landlord can ask about the disability. However, the landlord doesn't get to get all the medical records and the diagnosis and the prognosis. They get to inquire basically what type of disability. If the reason for the accommodation that they're requesting is not apparent, then the landlord may require why that particular accommodation is needed. For instance, if a person comes in a wheelchair and says that the door to his apartment needs to be widened, well, there, the disability is obvious, and the request is clearly related to his disability. He can't get through his door if the door is too narrow. Now, if a tenant in a no pet community comes to the landlord and says, I want a dog, if there's nothing that the landlord can see as to a disability, the landlord may ask, what is the disability that you're asking me to accommodate for? And if the person says, I have severe depression and I need a dog because a dog helps me with my depression, it relieves the pressure. And if they say, you know, my doctor has recommended that I have a dog, at that time, a reasonable accommodation will have to be made. But again, the accommodation must relate to the disability. Where a wheel-bound tenant asks for cupboards to be installed above the refrigerator because they want to store stuff, the landlord isn't required to make that accommodation because it doesn't relate to the person's disability, i.e. being in a wheelchair. If a landlord provides housing for people, but doesn't provide other services, if a tenant calls and says, I'm disabled and I would like, and I can't get out of bed, I need a shopper, the landlord can say, we don't provide shopping services that's outside of our business model, and they wouldn't have to make that accommodation. And I want to make sure that everybody's aware there are testers, there are people whose job it is to go to business establishments, different rental offices, and to see whether or not they are treated the same as other people who are different. In other words, somebody may show up to be testing and bring with them 10 kids, and they want to see whether or not you treat them the same, give them the same questions, offer the same leases, show them the same apartments that you would to a couple that comes as an elderly couple looking for a place to live. The penalties are very harsh. The tenant who is damaged is entitled to actual damages. There are punitive damages, statutory fines, attorney's fees, and injunctions. You do not want to be on the wrong side of a discrimination lawsuit. Rental agreements. Forming the landlord-tenant relationship means entering into a rental agreement. Although there are oral agreements, a rental agreement should be in writing. You definitely need to have a written rental agreement. The rental agreement will outline all the obligations and the duties that parties have to each other. It will tell you who pays which expenses. For instance, whether or not the landlord is paying for water, whether the tenant pays for water, whether the landlord pays for the electricity, the tenant pays for electricity. It also will include the rules and regulations for the rental unit. Those rules and regulations can be in the rental agreement itself, or they may be in a separate document entitled Rules and Regulations that are incorporated into the rental agreement. The rental agreement must be signed by both the landlord and the tenants. A properly prepared agreement should clarify the obligations. It should protect the parties from legal disputes, and basically it ensures a good relationship. Rental agreements can be customized to meet your expectations. For tenants, if you are given a rental agreement, you must understand that rental agreement. Do not sign that rental agreement if you don't understand the terms or you don't agree to the terms. It's no good later at an eviction process saying, well, I didn't read the agreement, or I didn't understand that term. If there's some question, ask. Don't sign if you don't agree. The law is and has been changing. 1950.5 became effective January 31, 2024, and within a few months, the legislature had enacted another law, which is taking place and effective July 1st of this year. And this is on the security deposits. In the past, landlords have charged often 2 months worth of rent and sometimes 3 months worth of rent as a security deposit for a furnished apartment or home. Here and now, with a minor exception, which I will discuss, landlords can only charge a sum equal to 1 month's rent. And the small exception is for natural landlords, i.e., an individual person, not a corporation. And that landlord must be a very small landlord, have no more than 2 properties, and combined, those 2 properties must not have more than 4 rental units. So it's a very, very narrow exception to the 1 month's security deposit. This law will take effect on July 1, 2024. There are also very different and new rules regarding handling the security deposit at the end of the tenancy. That is not something for today. I will certainly provide another webinar regarding that. Over the past few years, more and more tenant disputes revolve around pet policies. So I have specifically set some time aside in this webinar to discuss the 3 types of animal classifications. The first are service animals. These are animals that are specially trained to provide a specific service to a disabled person. They perform tasks such as guiding the person. They are sometimes signal dogs. They tell a deaf person that somebody is at the door or the telephone is ringing. They will tell people if they are having a seizure. There's the seizure detection dogs. They are not considered a pet. They are not subject to your pet policies or your pet fees. There are only 2 permissible questions that a landlord may ask, and these are specifically set forth in a statute, and that is, are you an individual with a disability? What is that disability? And how does the animal relate to your disability? So if you see a person, they say, I'm blind. And then you say, what is this task related to your blindness that this dog performs? The dog guides me. You can't ask for a demonstration. So if a person says that the dog is a seizure dog and detects that when you're having a seizure, you cannot then say, well, demonstrate that what the dog does. You're not allowed to do that. Now, the next type of animal is an emotional support animal. An emotional support animal does not have to have any special training or be certified. A support animal is generally considered to be a reasonable accommodation for a tenant who has a disability. Some questions are permissible. You are allowed to ask about the disability. You can ask at that point for a treatment plan or some indication from a medical provider. You are not allowed to demand a pet fee. You can't charge them additional rent. You can't charge them a security deposit. But both the service dog and the support animal do have to abide by some of the general rules in your community. For instance, waste removal, making sure that they're vaccinated. What you can't do is have rules that say they have to be on leash if the leash would interfere with their ability to do their job. For instance, a signal dog may be trained to nudge a person and then they run to the door to tell the person that somebody's at the door. A leash would interfere with such training. The same as with a guide dog, putting a leash on a dog when a dog has a handle on the back, the leash would interfere with the blind person's ability to handle their dog and the dog's ability to work for the person. The rest of the animals in the communities, those are pets. Now, currently, we are allowed to have no pet policies, but there's a brand new law, or at least a potential law. It's AB 2216, which, if passed, will allow all tenants to have pets. It has already passed the House with 46 yeses and 9 nays. It is now with the Senate. The prediction is, although no one knows for sure, that it will become effective in January of next year. We don't know for sure, but it may well do. And that will change what I'm about to tell you. But at the moment, we are allowed to say that your community has no pets. You can also require a pet deposit. You can put restrictions on the breeds and the weight of a pet, such as saying you can have a dog of a certain size, no more than 30 pounds. You can have a cat, you can have a bird, you can have a hamster, you can put the type of animal. But again, these do not apply to your service or your emotional dogs. You have a number of pets that you can limit. You can look at and say we have 2 pets. You could say we can have 1 dog, 1 cat. You have rules and may have them regarding waste removal, how quickly they need to be removed. Behavioral expectations are also something that you're allowed to have rules on, such as they can't bark, noise, they can't be a nuisance to their neighbors. You can also require them to be registered with the city and the county. In pet policies, there are some jurisdictions who have passed ordinances regulating some of the things that you can and cannot require. So be sure in your particular community that you look at the ordinary local rules regarding pets. Landlords often will dictate where a pet can go to the bathroom, but you can't ban them entirely from the community. So in other words, if you say that you allow pets and you tell them they can't walk the pets on any of the sidewalks, on any of the grass, on any of the paved areas, you have made it impossible, and therefore that would be a prohibited rule. You can say that you have certain designated areas for pets to relieve themselves, and as long as those are reasonable in the sense of they're close to the various tenants' properties so that they can go out and relieve the dogs, you won't have a problem. You can't impose monthly inspections. You can't require pets to go under treatment such as declawing to make them, or debarking. Now we get to their area of evictions. And I have some tips to avoid evictions. And those tips are basically, if an issue comes up between a landlord and a tenant, either one should go to the other and explain an issue to see if there can't come to a mutual agreement. If you're a landlord, it's often good to give a warning as opposed to a really nasty notice to start. If you go to them and say, look, you've got to move those boxes off your porch, they can't be there. And if you're a tenant, you can go plead for mercy. I'm so sorry, I've got the boxes here, I just need another week, my son's going to come get them. But you try to work out a mutual agreement, an apology, and asking for forgiveness. If there's something that you need and come to an agreement on, revise the rental agreement so it reflects the new terms that you've agreed upon. There's always arbitration. and mediation. Arbitration means that you're going to go and take a dispute and you'll agree to be bound by whatever determination the arbitrator makes. Mediation is one of those places where you're looking for a third party to help you work out a dispute. And those can be ways to avoid a nasty eviction. In the eviction process, what happens is the landlord will give the tenant a required written notice telling the tenant that they are going to have to either change their behavior or they're going to be terminated, or in certain circumstances, go straight to a termination notice. The landlord will then file an unlawful detainer action against the tenant. And now, brand new law, 1946.2, which became effective April of this year. It is just cause termination. And this new law affects any tenant who's been in the property for 12 months. Where during a year where the tenants change, and you have some adults moving in and moving out, if all of those tenants have been in the rental unit for 12 months, then the law is effective. If one of the tenants has been in the rental unit for 24 months, you're subject to the 12-month rule. The penalties for violating the just cause eviction process are very harsh again. There's actual damages, attorney's fees and costs. Then there's triple damages. So what they would do is they would triple the amount of actual damages. And it's also possible that the Attorney General can step in and demand that you have an injunction against you to prevent that type of behavior. Now, the just causes are divided into two types of matters. First one is at-fault cases. And these are cases such as one where there's a failure to pay rent, there's a violation of a lease term, the tenant is creating a nuisance on the property, where there's a refusal in certain cases to renew a lease where they're required to under the lease terms. If they have sublet, meaning they brought somebody into the rental unit without your permission. It can be for criminal activity where they are selling drugs out of the property, or they're a gangbanger and they have wild, unruly parties with guns and the like. It can be circumstances where the tenant refuses to allow the landlord into the premises after the landlord has given proper notice. It's also a time when there's a failure of an employee who is provided housing as part of their employment, if they refuse to vacate. And it's also used when a tenancy has terminated. They had a 2-year lease, the lease is terminated, and they don't vacate at that time. These are at-fault causes. An at-fault clause may require 2 notices. If the cause, if the fault is one of a nature that can be cured, where we talk about somebody failed to pay rent, then a notice to cure is given. You must pay your rent within 3 days or your tenancy will be terminated. They had 3 days to cure the notice. If the lease requires that a tenant be given 7 days to abide by one of the rules or regulations in the community, then a notice to cure would say you have 7 days to cure this violation. And if you don't, your tenancy will be terminated. Once the time period to cure has expired, then another notice is given. And this notice just says you are being terminated for failure to cure. You must vacate the property. And that gives them the notice that they have to vacate the property. So it's 2 sequential notices given when you're dealing with an at-fault termination where the event is one that can be cured. No fault causes. These are circumstances where the landlord wants to take the property off the rental market, or whether they've been ordered by a government agency to stop renting the property. So if they have to stop renting the property to comply with a government order, it's a no fault cause, it's a just cause. If a landlord intends to demolish or substantially remodel a unit, and the tenant is going to be required to be out of there for at least 30 days in order for the demolishing or substantially remodeling to take place, then it's a no fault cause eviction. But if they're doing substantial remodeling, that has defined very clearly by the statute. It cannot merely be that you're going to paint the premises, because a tenant can stay in where you're going to paint, or it only needs to vacate for a few days while you paint. It has to be a substantial remodification. The other area is occupation of the unit by the owner's family. And the code is very clear. The family that is allowed to do that is the owner, the owner's spouse, the owner's domestic partner, owner's children, owner's grandchildren, owner's parents, owner's. It is not for the owner's nieces and nephews. It's only for the owners. And they cannot do that if there's another unit that's similar to the one available, or in a situation where the person is already residing in a unit. They can't make a person move so they could have a different unit. When you're giving notices based upon a family member wanting to move in, you have to give the name and the relationship of the person who would move in. The tenant has a right upon request to have proof that this person is related to you. And if the person does not move in within 90 days and remain for 12 months, the tenant has the right to relet the property. With substantial remodeling, the notices have to have a description of the remodel, or if it's demolition, what is being demolished, copies of permits. If the work doesn't require a permit, then you must present to the tenant a signed contract for the work, showing that there's going to be a certain contractor who is going to take down the roof, and going to take down walls to do a remodel job on it. And if it doesn't occur, then the tenant has a right to relet. In the no fault termination, a landlord is required to give 1 month's worth of rent free or relocation assistance. Relocation assistance amounts to giving a tenant 1 month's rent to use to be able to find other accommodations, and that 1 month's worth of rent has to be given within 15 days of them receiving the notice. So in one circumstance, they don't have to pay a month's worth of rent and can use that money to relocate, or in the other circumstances, the landlord has to give them the actual cash to go and relocate. And as we just discussed, the notices must provide the information, the reason for termination, where owners and relatives will move in, the names and addresses of those people. For tenants, evictions require immediate action. So if a tenant, you receive a notice, you have to act very, very quickly. Time is of the essence. If a notice says you have 3 days, it means you have 3 days. It does not mean you have 7 days or 8 days or 10 days. It's 3 days. So if you have 3 days to pay the rent, you need to make sure you paid within those 3 days. The day you get the notice is not counted. So if the notice is posted on your home, that day is not counted, but the next 3 days are. If it falls on a for paying of rent. If it falls on a holiday or a Saturday, Sunday, you have until the following Monday to pay. But again, it's a 3-day notice. You need to act quickly. If you're given 7 days to take care of a problem, you need to do that. Some lease agreements require 10 days notice, but you have that 10 days. If you think you're not going to be able to do what is required within the 3, 7, or 10, or whatever period of time the landlord has given you, the best thing to try to do is within that time period, go to the landlord, explain to the landlord the issue, and see if you can't get the landlord to agree to give you more time. There's no requirement that they give you more time, but many will, because many don't really want to evict you. They want the compliance. The notice to cure, tenant's course of action, as we just talked about. If you have any question about how to cure it, go talk to the management and ask them, how do I fix this problem? If you're going to fix it, tell them, I am going to fix, I'm going to mow the lawn, I am going to put the door back on the hinges. I do what they're asking you to do and cure it as absolutely soon as you can and within the time period they've given. If after you've given a notice of termination, an unlawful detainer is filed against you, you need to file an answer. You will have 5 days from the time in which an unlawful detainer is served upon you to file an answer. You need to file the answer with the court. You need to serve the landlord with a copy of it. After an answer has been filed, most likely the landlord will file with the court a request to set the case for trial. Trials are usually held within 20 days of the answer being filed. If there's a trial date, appear at the trial. And at trial, be prepared at that point in time to present all your evidence that you can of how either you cured within the time period, how you were never in violation in the first place. The best thing that you can do, though, if you are and you know that you were not in compliance or didn't bring yourself into compliance within the time period, is to try to work out a solution with the landlord. The solution can be worked out something other than eviction. Sometimes the landlord will say, I will agree, I will accept your rent now, we can work it out. But you want to make sure that you try to work a settlement. One of the settlements can be, we won't have a lockout before a specific date. You can have the landlord agree to allowing you to pick up your property within a certain period of time later than what normally would be allowed on an eviction. Or you can agree that if you're allowed to stay for a few extra days, that the landlord can show the property during that time. The conclusion here, how can we help you? Well, we can help you work out a rental agreement. We can help you determine what are the essential terms that you need. If you want rent, then we need to make sure that we have an exact amount of rent that you want to be paid. Who is going to pay for the electricity? Who's going to pay for the water? Do you want to have them paying to have a gardener? Do you want to pay to have a gardener? These are things that a landlord should be considering. We can certainly work with you to decide what you need as the essential terms in your rental agreements. You want to have and create terms that are clear, concise, so that so a tenant can follow it, and that are relatively easy to comply with, so that there's no question about whether or not they did or didn't comply. Over the course of time, as we've discussed, the law changes. So do the circumstances around your rental property. So one of the things that you need to consider is updating and changing the terms as the law changes, as the rental properties change. We can help you navigate the anti-discrimination laws so that you find that you're advertising properly, so that you are not discriminating in the manner in which you are dealing with prospective tenants. We can help you navigate the law with respect to dealing with people who come and ask for reasonable accommodations. We can give you advice preparing the notices that need to be prepared for both eviction and just to obtain compliance from your tenants. For tenants, we can provide the same. We can provide assistance in navigating with and negotiating with the landlord regarding reasonable accommodations that you need to be made. We handle prosecuting and defending evictions, so we're there to help you with those if needed. Why our firm? We are a long-standing firm. We've been in existence for 45 years. We have attorneys trained in multiple areas. We have attorneys with the tax degrees. We have attorneys specializing in probate, estate planning, trust law. We have over 45 support staff, 8 offices to help you. And at any point in time, we're here to help you. You can reach us, and here are our telephone numbers, our website, our email. And at the conclusion of this, we ask that you give us a digital evaluation. We ask that you check the link in the chat and go through that. Now, what I'm going to do now is see if we've got some questions and see if we can answer some of these questions. One question here is, are pet deposits in addition to security deposit? What is the maximum amount of a pet deposit? Pet deposits currently are in addition to regular security deposits. That may change if 2216 becomes the law, because at that point in time, there will be no security deposits allowed for pets. The maximum amount is an amount that is a reasonable amount to cover damages caused by the pet. So if they're bringing in a dog, you can ask for enough to cover scratches on doors or chewing on a door. Usually the amount is no more than about $500. If it's asking for a hamster in a cage, you're probably not going to be asking for $500. It may be something more on the line of $100 to $200 there. Another question we have is, can you initially sign a contract to somebody with a service animal if your contract policy says no pets? Let me make sure the question is proper here. If somebody comes to you and they want to rent your apartment, and they come and they are blind and they have a guide dog, you can't say, oh, I'm sorry, I have a no pet policy, I can't let you have that. No, you absolutely have to allow them to rent. And you have to make that accommodation, which is you're allowing them to keep an animal in the property. There's no question about that. The same is true if you have a no pet policy and somebody comes to you either before they rent or after they rent and say, I'm a person with a disability, and I use the example of somebody who's very depressed, has severe depression, and they say, my therapist recommends that I have a dog, or a cat, or a hamster, or a bird, or a pet of some description that they describe, and that animal helps alleviate some of my symptoms. You're going to have to work with them to make a reasonable accommodation. And you're not going to be able to impose your 15 pounds or your 20-pound animal. If you allow cats, you can't tell them you have to take a cat if they want and say they need a dog. Then the next question here says, ask because a former renter had a pet that chewed up cabinetry and was a nuisance to the neighbors. A reasonable accommodation to allow someone to have a service animal or to have an emotional support animal still requires that the animal meet some behavioral requirements. A guide dog cannot be vicious and attack other residents. A service dog cannot be, that is providing emotional support, cannot be outside howling all night long and disturbing. That is something you can prohibit and work with, but you can't just say they cannot have the animal. So if the animal is a nuisance to a neighbor, it really depends on the definition of a nuisance. If they're just saying they don't like having an animal there, or they hear an animal bark, that would not, occasionally, that would not be enough. If a person is deaf and they have a signal dog, the dog is going to most likely be barking to let the person know that somebody's at the door, to let them know the telephone's ringing, or let them know that the teapot kettle has sounded off. Things that when they hear a certain noise, they're trained to communicate that. So that would not be something that would be considered a nuisance. But a dog that just barked all day long constantly would be a nuisance, and it would be something you'd be able to do something with. There's a question that says regarding AB 2216, is there currently an exception for individual persons with no more than 2 properties written into this proposed law similar to AB 12? No, there is not. The current version of AB 2216 provides that any tenant can have a pet, and there is not a limit on that. Where the exception is going to come is if you were renting a room in your home, that roommate would not necessarily get to have a pet under what is currently the proposed language of 2216. Question here says, are there professional tenants that intend to profit from forced litigation? I think the answer is there's a few people out there who know how to maneuver and will take advantage of the laws so that they do get the punitives, they do get actual damages. So the issue is you must bring yourself into compliance, because those that are quote unquote professional tenants, they're doing what the law allows them to do. So there are some, and they do know the ways around. So make sure when you're dealing with people that you're dealing correctly, and we can help you with the professional tenant. There's a question here from Kurt that says a landlord wants to interview as many as possible. This could be construed as, and I'm not quite sure where the question goes, but I think basically, if I understand it, if you have a rental unit that's open and you take applications, you can conduct several different interviews with all the applicants, and you can choose the best applicant. But what you can't do is do it on a discriminatory basis. If you decide to take and use a standard policy, the person who I'm renting to, must have income of X dollars. The tenant must have credit of a certain standard. You cannot vary that depending on, well, this is a retired couple, so I let them have less, or this is a single mom and I take less. But you can go through. You do not have to take the very first applicant just because they meet some of your qualifications. You can interview others. There's a question that says, are these general rules for California or national? If we have properties in another state, does the no more than 2 rentals apply to us? The just cause eviction is only in California. The exception is allowing a landlord in California who has 2 properties in California with no more than 4 rental units. The properties outside of California would not cover for that. And if you have properties outside the state, those will be subject to whatever the jurisdiction requires. One of the questions asks, whether or not certain jurisdictions have rent control. Many jurisdictions have rent control, and the only way to go through is either to contact an attorney and ask them if there's rent control for a specific area or specific city, or go on to that particular city or that county's websites and look to see whether or not there are rent control ordinances. And rent control ordinances will affect the amounts that you can charge tenants and the terms of rental agreements and the terms of evictions. And those are something to be very watchful for. There's a question as to whether or not you can receive a copy of the slides. And yes, the slides can be made available to you. Just ask and we will provide those for you. And at this point in time, I'm going to conclude this webinar. I hope I've answered most of your questions, and I will have some further webinars later.